We're going to get started pretty much right on the money. We have a big virtual audience in attendance as well, and we have a lot of ground to cover. And so if I can get Kristi to stop talking. Anyhow, thank you all very much for joining us. I'm Ann Toomey McKenna, and I'm a law professor here at Richmond. And I'm also a privacy attorney, and I've had the really good fortune to work with several of our panelists in that role. You know, we couldn't be talking about a more important topic today. So I first just want to talk and quickly introduce our distinguished speakers. I'm going to come back to a little bit more about them because I also want you to meet the students who are the real stars of today, who made it possible. In particular, our Tech Law Society and our Black Law Students Association. But I've got Lynn Dupree right here. Lynn is a partner and leads the privacy practice group at Finnegan. Finnegan is truly a global intellectual property firm. They have offices across Europe, Asia, and the United States. And I'm going to come back more to Lynn because there's a lot. And Kristi Scott is the Associate General Counsel with the Central Intelligence Agency. And Brian Shull is Senior Enforcement Attorney with the Federal Trade Commission. And you're going to hear a lot of acronyms today, so let's just get that CIA and FTC one out of the way. And so the student organizations who made this possible by sponsoring it are the Tech Law Society, and I want to thank them and their president, Jessica Birdsong, who you're going to hear from in a few minutes, and I'll introduce her, and the Oliver Hill chapter of the Black Law Students Association, which you'll hear me call BALSA for the rest of today. In terms of, and particularly BALSA's president, current president, Courtney Mason, and you're also going to hear from Catherine Threat, their incoming president for next year. The student planning committee consisted of Jessica Birdsong and Catherine Threat, but also a group of students from my cyber law and information privacy law classes. And with the help of AI, we came up with some cool graphics for the event. But really a tremendous group effort. These are the students who framed what the conversation was going to be about and handled all of this. So a debt of gratitude to all of them. And they're Cameron Baxter, Nathan Crispo, Bethany Jones, Kim Lowe, and then two students in particular, Kyle Resurrection is assisting behind me today with questions. So for those of you who are attending virtually, Kyle and Deandra are going to be going through, looking at your questions when we get to the Q&A at the end, and we'll also have audience Q&A. A couple quick things. Kyle is doing amazing research right now in the area of in the use of generative AI in healthcare. And Deandra has done some really interesting research on deepfakes and democracy. And in particular had a paper that was selected for publication in the spring 2024 edition of the Legal Pad, which is the National Black Law Students Association's legal publication. And she was featured at the 56th National Conference. She's also presented on her paper to the Virginia General Assembly this legislative session. So again, a debt of gratitude to these students who made this possible and to these organizations. I want to now really quickly call up in a minute Jessica Birdsong. She's a third-year law student. You heard she's the president of Tech Law Society. She really brought some energy into that group and revived that society. She, in addition to being the president of Tech Law Society, she's the article editor for the Journal of Law and Technology here at Richmond, Shull, another acronym you'll hear thrown around. She's a justice on our honor council here at the law school. She's a member of Richmond Women's Law, the Trial Advocacy Board, and the Students Intellectual Property Association. And after law school, she's going to be practicing regulatory litigation at Troutman Pepper here in Richmond. And then right after Jess, you're going to hear from Catherine Threat, who is a current 2L at Richmond Law. Her work in cyber and tech is really remarkable for someone who is a 2L law student. She's the incoming president for BALSA. She's also the incoming executive editor for Shull. And her interest in this intersection of law and technology was, started in undergrad, but it really came to fruition, both for what she's done with Shull, but also she participated in a certificate program with the Federal Communications Bar Association, which was sponsored by the FCBA Tech Bar. And she also did an internship with the Tech Counsel for Lululemon. And I know some of us would like to know the inside on that. So without further ado, Jess, thank you.
Hi, everybody. Thank you for joining us here today. As Professor McKenna so kindly mentioned, my name is Jessica Birdsong, the current president of the Tech Law Society here at Richmond Law. My journey with this organization started during my first year as a law student when I received an email about an event being put on by the Tech Law Society that advertised free lunch. So I thought, sure, I'll go. And after listening to the speakers talk for an hour, I realized I was so captivated by the content that I had barely even touched my free lunch. Needless to say, I immediately emailed the then president asking how I could get involved in this organization. Since then, I've learned that from its inception, this organization has remained steadfast in its commitment to fostering intellectual exploration amongst our peers. Our overarching objective is to facilitate an understanding of the way technology and innovation interact with our current legal framework and policies. As we all know, technology often outpaces the development of their corresponding legal frameworks. And in an era characterized by rapid technological evolution, the Tech Law Society stresses the importance of legal professionals understanding the emerging technologies to then be able to address the legal issues arising from their use. Today's presentation speaks to exactly this concept. I look forward to hearing from our speakers today, discuss strategies that can mitigate these impacts and foster responsible innovation. Thank you.
Good afternoon, everyone. On behalf of our current chapter president of BOLSA, Courtney Mason, the 2023-2024 BOLSA's Executive Board and its membership, BOLSA is incredibly honored to host Pandora's Pixels with the Tech Law Society. Thank you all for our panelists for your participation in today's events and especially for this moment. As Professor McKenna mentioned in her introduction, my name is Catherine Threet, and I am the current Director of Programming for the Oliver Hill chapter of BOLSA and the incoming chapter president. The Oliver Hill chapter of BOLSA was founded on the campus of the University of Richmond in the late 1970s. Our chapter's mission is to center the needs of Black students on this campus and to work strategically to address those needs so that students can excel academically, succeed professionally, and positively effectuate change within the community. We are proudly named in honor of the trailblazing Richmond attorney, the late Oliver Hill. Attorney Hill spent his life tirelessly working so that underrepresented groups had equal access to opportunities in pay, quality education, protection of voting rights, and beyond. And that is why it's so fitting that we have the opportunity to be present today. As a future lawyer hoping to practice at the intersection of technology, fashion, and the arts, the importance of having diverse voices in the conversations surrounding the tension of innovating with generative AI and protecting our privacy is apparent. The intersection of technological innovations and privacy law is changing the legal field and the daily lives of everyday citizens. Diverse viewpoints must be at the table to determine how this emerging and ever-changing field will shape the future of legal practice and ensure that vulnerable communities are not adversely impacted. I am so excited to hear from today's amazing panelists, and I know that if Attorney Hill were alive today, he would be ecstatic to see how individuals like our panelists are breaking down barriers to be leaders in this emerging field of law. Again, thank you to everyone for being here today. I'm looking forward to the conversation, and I am turning it back over to Professor McKenna.
Thank you, Catherine. And I'm going to start with an apology to Miranda Bogen because she is our virtual panelist. So I was like, oh, I don't see a physical body. I forgot. Miranda Bogen is the founding director of the AI Governance Lab at the Center for Democracy and Technology. You might hear us throw around the term CDT just to add to your list of acronyms. So let me give a little bit more about Miranda, and then I'll give a little bit more as well. Prior to joining and standing up the lab at CDT, Miranda helped to lead strategy and implementation of responsible AI practices at Meta. And heaven knows we all need that. And she works now on robust technically informed solutions for the effective regulation and governance of AI systems. A little bit more about Kristi Scott sitting here. She's the former Chief Privacy Officer of the CIA, and in 2022, she received the Presidential Rank Award. It's the highest civilian award. She was awarded this by President Biden, and that civilian award is awarded for exemplifying meritorious service within the intelligence community. Prior to joining Finnegan, Lynn Dupree served as the Chief Privacy Officer for the United States Department of Homeland Security, DHS, you'll hear us mention. And prior to that, she served as the Executive Director of Privacy, Civil Liberties, and Oversight Board. Brian has been at the FTC since 2013, and he's doing a lot, leading efforts to protect all of us. In terms of, he served multiple roles, including as the attorney advisor to one of the former commissioners, but he leads the FTC's enforcement efforts relating to data brokers, for-profit education, and mobile cramming, which he'll tell you about in a few minutes. First, a very brief explanation of how we get here. We're talking about generative AI, privacy, and choice. And just for that framework, there's a lot we could cover. And even in the preparation with each of these speakers, we recognize that just one of them could talk for an hour and not even get across half of what should be communicated about this very important subject. So I just want to take literally a minute or two, and I'm going to cut this down to keep us hearing from our speakers. It's really important to stop to think about data, right? And that how this ecosystem, this information ecosystem works. And many of you, particularly students I know that take and study courses in this area, are aware of this, but we don't stop to think about how we're surrounded by smart devices everywhere we are. We wear them, they're around us in work, we're being recorded now. Every device we interact with is embedded with sensors. These sensors are incredibly sophisticated, incredibly tiny, and they're ever increasing in their abilities to collect data. All of these devices form part of what we call the IoT, the Internet of Things. And I think most of you have probably heard that term. But the IoT relies on this data aggregation. And as technology and the algorithms and AI systems have evolved, we've really developed, and this is a big part of our marketing world, a concept of Internet of Behaviors. And the Internet of Behaviors relies on all of this data that is aggregated about us. Those IoT devices, those smart devices that I'm talking about, it's really important to recognize that they autonomously connect with each other and communicate with each other. You don't control that, and you don't have control over it. It's just a false notion of control when you hit do not track or turn off location services. Again, there's so much data that's being aggregated and collected. And so the Internet of Behavior is significant because IoT means that the data that's in the cloud, it just continues to grow. It continues to aggregate, but aggregate in ways that collect and are able to collect more insights, because so many data points are being collected about us. You get in your car and you're immediately being subject to sensors collecting data about you. So the aggregation of this data, coupled with advancing AI systems, enables increasingly advanced and accurate insights about our behaviors, our desires, and our expectations. IOB also brings together existing technologies which directly focus on individuals, like facial recognition technology, location tracking, big data. It combines science, data processing, and the psychology of human behavior. I think it's helpful to hear the words of a marketer describing what IOB, the Internet of Behaviors, provides. IOB's goal is to record, analyze, comprehend, and respond to all forms of human behavior in a way that allows people to be tracked and interpreted using developing technology advancements and advances in AI systems. And that's a marketer just explaining how it works. So when we think about this coupling of data, right, this global data market that I briefly described, and data brokers, which Brian will explain more for us about it, it's this massive amount of publicly available information, commercially available information, coming from an increasingly advanced array of resources, and it has ever advancing predictive capabilities. Generative AI systems have ever increasing abilities to use that data. So we have these models, these generative AI models. And one area that I think Miranda will touch on for us, I'm going to start with her as our technology expert here today, is what these systems look like. And she's going to give us some definitions, because when people talk about AI, we throw around terms. We're going to break that down a little bit and make sure we all start with that. And I think Lynn will talk a little bit, you and I talked about open sourcing AI, but I want to get this turned over to you all right away. So Miranda, lots of terms, they get thrown around in these conversations. To get us started, can you explain, when I'm using these words, predictive AI, generative AI, and I know in our conversations, large language model, foundation models, and frontier models, like, what does that mean? How do these systems work? Can you take it from there?
Absolutely, and thank you so much for having me. I'm sorry I couldn't be there in person, and I can't promise definitions, but I can at least walk through some of the characteristics of some of these different terms. I think the fight over definitions is an ongoing one. Where do you draw lines between certain systems and other ones? But, what we had thought of as AI in the context of AI policy and law, in up until about a year and a half ago, were these predictive systems that were basically saying, is that there's an action that we want to predict, an action, a characteristic, some other piece of data that we want to predict based on an array of other data. And developers would use machine learning, various different methods to say, what is the relationship between the inputs to that outcome, and looking at the historical patterns between those inputs and those outcomes, and saying, given a new set of inputs, how likely is it for, this entity, this person, this, whatever it is that you're looking at, how likely is it for it to fall into that category, to lead to that outcome, for someone to click on that ad, for someone to commit a crime. We've seen all of these different examples, but it's generally, you had the inputs and then you had labels. So supervised learning to say, this is what this type of example looks like, tell me how to get there. With the mess of foundation models, generative AI, large language models, frontier models, largely those are doing something a bit different, which is not starting with what is an outcome we want to predict or a specific a characteristic we're trying to map to, but rather saying, among this enormous pool of data, what is the relationship between these data points? And letting the computers sort of decide for themselves what are the relevant signals that pertain to that relationship. So taking large language models as an example of a type of foundation model, those are basically trying to map the relationship between words or parts of words to say, does this part of this word or this string of words appear most often with what other words, such that in the future, we might recreate reasonable strings of words that have happened in the history of language. But it's not saying this is this type of word, use this grammar, follow these rules. It's just saying, here are trillions of data points, find some relationship between them. And there are different methods to do that, and then to test if it's been able to do that. But the approach to it is really looking at that broad set of data and just like unleashing different training algorithms on that. Now, how does this relate to the bigger picture of, I think, today's topic of, what role data plays, is that research has shown that the more data that you use to train these foundation models, the better they are at whatever task they're being assessed on, generally. Not all the time, but some of the benchmarks that are used to assess how effective or useful foundation models are. Generally, if you throw more data at it and if you use more computers, the line is going up. And so developers of these foundation models are really hungry for more and more data, because they see that as fueling greater and greater capabilities, leading potentially ultimately to systems that are able to interact more autonomously, to like plan, think ahead. I'm using anthropomorphizing terms. I try not to, but that is what the people developing these terms, developing these systems hope for this technology. Generative AI as sort of a subset of, foundation models generally means predicting the next piece of content, whether that's a word token, a few word tokens, a pixel, etc., based on an input or a seed piece of information to say what is most likely to come next. given this sort of input prompt. And in effect, that means the generation of language and art and, things like that. But the mechanism is producing sort of these specific components, like piece by piece. And so there are lots of debates over, is that intelligent, or is that just predicting, word tokens, and how do we parse that out? And then lastly, I'll say to, frontier systems, that's Kate, how advanced these systems are, how much data they have. Are they exhibiting new capabilities that people didn't expect them to exhibit, which sometimes is happening as they're getting bigger and bigger. A big problem is that most people developing foundation models are not disclosing what data they use to do that training. And so you don't actually know if the data you're using to test the model was part of the training data. So there's this, we can't necessarily be sure that the tests are really indicating frontier or highly advanced capabilities, because they could have just seen that data in training and we're not sure about that. But frontier is basically the newest, biggest, most capable versions of foundation models that can seem to perform tasks that maybe previous more narrow systems were not able to do in that sort of autonomous way.
Thank you very much, Miranda. And you did a great job explaining all those things. So thank you. I think that gave us a working definition, right, of these different things. And part of this question is that you raise is we don't know what's happening in the box, right? That is a very difficult problem, both for researchers and engineers and technologists. It's also a problem for us as lawyers. Right. We know, remember, generative AI was released to the public last summer, and we all got on and we were like, how quickly we could have it create things saying certain professors were convicted of crimes that they were never convicted of. And there was an actual Washington Post article about it, which wasn't actually in existence. So we all saw these different kinds of things. And it's this area, our speakers mentioned earlier that disconnect between technology and law, right? And that's, I guess, where I want to turn to you, Lynn. What is our current framework of law and the regulation that governs these systems and the information ecosystem that I described and the AI systems that Miranda described?
Well, I think we are in a somewhat of a patchwork of laws. So just to back up a bit, historically in the United States, we did not have comprehensive privacy laws. We had sector-specific privacy laws, generally, healthcare privacy, heavily regulated, financial privacy, heavily regulated, and then everything else, primarily unregulated. And so we have moved into this new era, kind of kicked off by GDPR in the EU, where states in the United States have followed suit, and they're, passing their own state comprehensive privacy laws. And so these laws, are thematically the same. They have specific nuances. So generally speaking, they are going to be focused on providing increased individual participation, meaning, having strong notice and consent requirements, having significant financial penalties, just because if you don't have significant financial penalties, companies will budget in fines if they're not significant. So you see in GDPR, 4% of annual worldwide turnover for some violations. In the US, you tend to see penalties that are like $7,500 per violation, which adds up very quickly when you're doing data at scale. So you're seeing these laws really try to incentivize compliance through financial penalties. The other thing you're seeing in the laws are increased governance responsibilities. And I highlight this because for the private sector, this is very, very new. So all of us have government experience. We know that governance and compliance responsibilities are very common in government. We have responsibilities to do impact assessments and risk assessments and make them public. That has never been done in the private sector before. And so all the laws are similarly having these requirements to do assessments. So we've got a patchwork of existing state laws and then other bodies of guidance. I look heavily to FTC enforcement cases to figure out, particularly as it relates to artificial intelligence, what are the factors that we should be paying attention to? We've seen some decisions recently that, again, kind of mirror what we see in privacy law, where we see, emphasis on individual participation, a different kind of emphasis on fairness and impact and equitability. And those are the things that I'm really looked to from the FTC. And then we have guidance. So we have executive orders on the use of artificial intelligence. We have an executive order on the sharing of bulk data with countries of concern, and that's, China, Iran, Russia, Venezuela, and another country, North Korea. So much of this is still in flux, but again, we can draw some thematic similarities, and we can see the fair information practice principles that are deeply embedded in privacy law kind of showing up in various ways, and particularly FTC enforcement decisions. But I think you can draw that line from privacy to unfair trade practices, and they get to privacy through unfair and deceptive acts.
Thank you, Lynn. And I know we have this, question about data and how the law protects it and these types of data, which Lynn explained. One of the things is remembering, Lynn mentions consent. Every time you download an app, like those clicks, I agree, you're agreeing to things that you're not reading and understanding, and they form the basis of a way to circumvent all the legal protections that the law would otherwise provide for your electronic communications, for all kinds of things. And so part of this change and shift we're seeing is what data is protected, and is just trying to continually enumerating types of data enough? It raises a lot of questions, and I know we're going to come back to that, but Kristi, I want to turn to you. We know this already from other sources, but in particular, we know the Office of the Director of National Intelligence declassified last summer portions of a report regarding the use of commercially acquired information in federal agencies. What data did they have? How are they using it? And how are they using it with AI tools? So we know that governments in general utilize data and AI tools. But how do agencies parse out, right, this use of commercially acquired information and advancing data analytics in accomplishing their respective missions, while still, maintain domestic security, maintain national security, but preserve civil liberties? It's a tough line to walk because all of these commercial actors have all of this data.
Yes, it is a tough line to walk, and I think it's really a shift in thinking within the law enforcement communities as well as the intelligence communities, because historically, open source information or intelligence has been collected since the beginning of the early 1920s, and it was considered to be not intrusive information, because if you think about way back in the day, publicly available information or commercially acquired information was a telephone book, and some of you may be too young to remember what a yellow page telephone book is, or a Rolodex. And that information historically was considered somewhat benign, because it related to routine information about maybe where an individual lived and their telephone number. But what has changed is not necessarily the underlying information, but the way where there is such technology that can be applied to this personal information. And one of the things that we talked about, which is important in the definitions, is what could on its face appear to be benign or not sensitive, quickly in the hands of data aggregators or data brokers can become extraordinarily intrusive. The fact that Amazon or Google knows that I have 2 kids, a cat, and my shopping preferences can be extraordinarily harmful in the hands of law enforcement or the intelligence community, because they have the ability to potentially implicate someone's privacy or civil liberties. So the concern, I think, for privacy and commercially acquired information is really at its zenith when it's in the hands of law enforcement or the intelligence community. One of the things that the report that came out that's publicly available on the Director of National Intelligence website about how the intelligence community could acquire this information, which, as I said, traditionally has been considered to be less intrusive, right? Because it doesn't require a court order, it doesn't require a warrant. And it's not historically considered to be intrusive. But the intelligence community really needs to understand how it acquires commercially acquired information, how it purchases that information, how it's used, and how that information is disseminated. So a big portion of the recommendations of that report, which I urge you all to read, and was really thoughtfully done by folks who understand kind of constitutional principles and Fourth Amendment search and seizure laws, is really to think about how we catalog that information, how do we use it, and how do we make sure that we build in some of those fair information practice principles. I think what becomes increasingly difficult for the issue of consent, which is a core fair information practice principle, and it's a sliding scale. So if you take away that consent, I think part of the question is, how do we on the back end make sure that we apply extra aspects of auditing information, making sure that only those individuals who have a need to know can access that information, and robust controls around and surrounding that information on the back end. But I do think that the notion of consent is not something that is monolithic, right? It's increasingly difficult to discern. We just click through those consent policies. No one really reads them. And I think it is going to become more and more difficult as these generative AI models and additional technologies are applied to the information to truly apply consent, because this information is being used in a way that secondary and tertiary use of that information could never really be gained.
Thank you, Kristi. I like how you described that consent question, because we see in legislation just introduced actually on Sunday, bipartisan, bicameral legislation in Congress called the American Privacy Rights Act. And it uses a definition that really clarifies express affirmative consent, really spells out some pieces of that. And I think, Lynn, you're probably going to come back to that, but I don't want to jump ahead. But this other piece of this is, what are you consenting to, right? What collection of data are you consenting to? And this other question and point that both Lynn and Kristi raised about different parts of data, like data points that we wouldn't think of as sensitive, have become incredibly sensitive. And most of us now can recognize why geolocation data is sensitive, but particularly with US Supreme Court decisions in Dobbs, we have geolocation data taking on a whole new meaning for half of the population, and particularly for citizens of Alabama. So this question about data and how we define it, Brian, I want to turn to you, because Lynn talked about how much she's guided by the FTC's work. And it was so cool to have my students have read your Kachava complaint, and then to see the executive order really following that concept. So we're really talking about the massive shift in what data needs to be protected and why.
Yeah, so as an attorney for the Federal Trade Commission, I come at these things from the commercial marketplace side of things, so different from the government side of things. But one of the functions of the FTC is we are tasked with studying different segments of the marketplace and then issuing reports about what we learned. And we have attorneys, we have economists, we have data analysts who work on these things. And back in 2012, we issued a report about protecting consumer privacy online. And the genesis of the report was back in 2012, and again, maybe hard to remember, hard to think, but the internet was really beginning to change and to shift. It was beginning to become a more mobile-focused internet. It was the Internet of Things was beginning to really become developed, and social media was beginning to explode. It wasn't just one platform anymore. It was, incalculable number of platforms that you can get on now. And so that was in that report, we expressed concerns about the sensitivity of the data that was being collected online. And we expressly called out things like geolocation, health data, information about children. And we also reminded companies that the FTC has long held that if you're going to collect personal information, sensitive information about consumers or from consumers, you have to get affirmative express consent. So I go over that, probably unnecessary and boring history lesson, just as a segue to my actual point, which is these concepts of sensitive personal information and affirmative express consent. They're not new in consumer protection law. We've been dealing with them for decades. But I do think to Anne's point that we are definitely talking about them more broadly, and the definitions are rapidly changing now. And I think one of the reasons why is because we're finally uncovering and discovering just how much injury and damage to consumers some of this data that's being collected about you online is doing. I just want to give 2 examples that bug me enough to share. So the first is from our X mode action that we announced earlier this year. And in that action, we alleged that X mode, who is a data broker, was tracking consumers who visited cardiologists' offices in the Columbus, Ohio region, and then sold that information to a company. So just think about that. That means that if you had a heart condition in the Columbus, Ohio region, a company you've never heard of was tracking you and sold that information for their monetary gain. And the second one, some of you may have read about it in the news a couple of years ago, but it was about the Catholic priest who was outed based on a newspaper had gained access to data brokers' information about what he had on his phone, about the geolocation places that he visited, and then what apps he had on his phone and how often he used them. So that's just 2 examples of how this information that's being collected about us online can be used and has been used to injure consumers. I think that leads to the broader question of, what does this mobile data reveal about us? And the short answer is everything. In our law enforcement action against data broker Kochava, we allege that Kochava brags that it has 300 data points about each of 300 million US consumers. And so for you geography buffs out there, you'll know that the population of the United States is approximately 330 million people. So what Kochava is actually saying is that they have 300 data points on everybody, every American who's old enough to have a phone, including probably every one of us in this room. And these data points can be things like your name, your address, your phone number, your email address, your device ID, your old device ID, so they can connect to you over time, your ethnicity, your gender, your work history, your financial stability, what locations you visited, how often you visit those locations, what apps you have on your phone, how often you open those apps, and what you do on those apps. And so it really, I like Sherlock Holmes stories. And I like especially how he can take what's seemingly innocuous fact and then deduce something important about a person. So like somebody's buttons on their left-hand sleeve are more worn out than on their right-hand sleeve, which means that they're left-handed and they write a lot for a living. But just imagine what Sherlock Holmes could do with 300 data points about you. And then imagine that Sherlock Holmes is a computer who has access to algorithms and search functions and database organization functions, all of which is able to, cut and dice this data any way that it pleases. And that's really what we're seeing companies doing. And we've seen this mobile data being broken down to tell whether you're an early riser, how often you exercise, whether you eat healthily, whether you have brand affinity, whether you like McDonald's over another company or one of their competitors, or whether you shop at Walmart or Target. But we're also seeing it broken down to even more sensitive characteristics like what religion are you? How often do you go to church? Are you a member of the LGBTQ plus community? What's your gender identity? Are you pregnant? What health conditions do you have? And all of this is being tracked by companies that you've never heard of and you've definitely never interacted with. And consent has been brought up, and that's really the consumer protection problem that we have right now. Is our consumer protection framework is really based on informed consent. So so consumers should have enough information that they're able to make informed choices about what products they buy and what information they share. And for example, if they want to buy a crappy product, as long as they have the information saying that this is a crappy product, then that's not a consumer protection problem. But how do you, and I think this was already kind of brought up, was how do you explain as complex of an ecosystem as the modern data broker ecosystem to somebody when you're just on your phone clicking, yes, I want to download this app, and yes, I want this app to, send me whatever. And the problem is it's even magnified because the screen space is so small. And so I think most of these companies aren't really getting informed consent before they collect their information. I think that's why you're seeing an increase in FTC enforcement actions. And it's possible that informed consent isn't even viable in this area. And if that's the case, then my argument would be that companies shouldn't be collecting this data, and they definitely shouldn't be using it.
And we've seen FTC has had some settlements which require disgorgement of data as part of that the companies disgorge the data that they have in their possession. So there's a lot of things you brought up in explaining all of that. And it's again, back to this question of informed consent, but it's also that you talked about that small screen size. And part of it is this threat that we think we're making choices, but are we really making choices, or is all of that mass of data about each of us just being used to shift us in a direction? So Miranda, I'm going to turn to you, because what do those risks look like in the context of choice? And I ask this broadly, not just about decisional privacy, but information about politicians, elections, choice, all kinds of individual choice. Because my students correctly really identified that as, how does the individual really know?
Absolutely. I mean, I think, starting sort of zoomed in, certainly, especially with the proliferation of AI-driven tools, or really any data collection at all, you would expect that you would be able to decide whether to interact with those systems. And we heard with, data brokers, that's not the case. With AI systems, that's also often not the case as well. People don't necessarily know that they're being subject to, profiling, automated decision-making, AI, et cetera. For people who are thinking about generative AI and chatbots, it might be a little bit different, because right now they're choosing to engage with things like ChatGPT. But in the future, if companies deploy, chatbots, and they don't disclose that that's an automated process and not a human, that's also something that many lawmakers have raised concerns around, that people should know if they're interacting with an AI system. But one of the interesting things about many of the foundation models out there, GPT-4, Claude, Llama, almost all, if not all, of the data they use to train those models is basically scraping from the public internet. It's not necessarily data that has been collected from first-party information or through transactions. Although, because of concerns around consent and intellectual property, we're actually seeing more deals where these, developers of AI systems are licensing data from places like Shutterstock or other providers, and that's seen as a good thing from an intellectual property perspective. But the concern around consent and proper use of data might be creating some strange incentives for companies to actually use first-party data, that they can assure the provenance of that data, but that might incentivize them to collect more data, which contradicts, I think, the goals that we generally have around consent. But of course, that's sort of the narrow conception of, do you know you're interacting with systems? Do you know if your data is being used for these bigger things? The challenge with AI systems, and this is the case for both predictive systems and more complex systems, is that individuals opting out either of their data to be used or for them to be subject to systems doesn't prevent broader impacts of these systems, of course. If you are absent from a data set, but you are similar to many other people who are in a data set, a lot can still be predicted about you. If you've chosen not to provide your data for training an AI model that will become, embedded in many, many different processes, that's not going to impact the systemic issues that are raised, whether synthetic data issues when it comes to elections and democracy, or labor displacement, or cultural homogeneity is another concern that many people have. And one other interesting dynamic when it comes to some of these gigantic models is that it could be that the people developing those models kind of ingest all this data, train these models, and then they sell those models, and they're not selling the data, but the models have learned a lot from that data, and sometimes they've memorized things from that underlying data. And so what does it actually mean to procure the use of a model and not the underlying data? And if you aren't sure about what data was used to train that, and there was some interesting commentary from the administration actually on the data broker executive order, or I think maybe it was one of the legislative proposals, that there was concern that some of those limitations would actually preclude the use of advanced AI systems. And my guess is that they made that assessment because right now there is no way to know what data has gone into these models because the companies aren't sharing it. There are ways to know theoretically, but currently there are not. And so it just sort of goes to show what a big mess the underlying infrastructure of these foundation models are, and the impacts that will have in so many different ways, and also the complexity of the policy interventions we need to think about, not just at an individual level, but also just addressing the practices of the people developing this technology.
Yeah, so I think that's maybe part of the things you're getting in there. And I know that we have like Professor Skalbach in here who's done a lot with the copyright lawsuits, or is very interested in that with these generative AI models. Part of it is that it's that scraped data. So one thing to remember is these generative models are going around and scraping data, scooping data. And this is where we see also tremendous harms because of inaccuracies and disparities that is in the existing data sets, right? And that inability. So I'm going to turn it to you. And I know we're kind of short on time here and we want to have some questions. So what can companies do? And is there a difference between companies using the tools and companies building the tools, Lynn?
Yes, I think there are very different, at least I advise companies that are trying to integrate tools into their business processes very differently than companies that are actually developing the models. And I would say one of my favorite cases, that I really sort of draw sort of guidance from is FTC versus Rite Aid. And I'll just sort of briefly highlight it because it sort of gives me some insights into like what a company should really be focused on, particularly if you are the purveyor of like the purchaser of a foundation model and then you're adding your own data to it. But essentially, Rite Aid decided that they were going to stop shoplifting or other activities in their store by developing basically a biometrically enabled facial recognition matching model, so that when someone walked into the store, they would be matched up against sort of a database of faces. They had, according to FTC, low quality lead images in the database. So when people would walk in, they might be misidentified. The FTC found that there was a higher rate of misidentification of people in plurality Black and Asian communities. The employees were instructed to, either identify and approach someone all the way up to calling law enforcement, which again, coming from an organization with law enforcement authority, I know that when you are about to involve law enforcement, you must be 100% accurate. And this tool just was wildly inaccurate, having, mismatches happen for like a single individual in multiple places within a time frame that it would be unreasonable for a person to be able to get to all of these Rite Aids, and what happened is they suffered algorithmic disgorgement. They were banned for using, by these tools for 5 years. They had to delete all of the data. They had to get all of the data from their vendors deleted. But more importantly, the FTC focused on the fact that they did not focus on data quality. Those lead data, the lead photos were not of the quality that you would need for facial recognition matching. And that they did no independent validation and testing that the tool did what it said it would do. So they took the vendor's word for it. They didn't do a lot of things. They didn't adequately train their employees. And so if you are a purchaser, to Miranda's point, what makes the way these models are trained are generally not going to be available to you as a purchaser. At some level, there's a risk inherent in that. But if you are going to deploy it in your environment and add your data to it, what's clear to me is that the FTC expects monitoring. It expects some significant analysis of impact, disparate impact and fairness. And so you can't just say, oh, well, we have a 97% accuracy rate. Yes, 97% sounds great, but if that 3% inaccuracy rate is affecting a single population, then you probably need to do something about it. And those are the kinds of things that I would advise clients. I'd also note that, we haven't talked about it. I didn't have enough time to do this, but there are some laws already enacted, Colorado in particular, related to automated decision-making. And the way they get to it in the law is they use the term profiling, and they sort of further scope it down to like profiling that has a legal or other similarly significant impact. And that's going to be the things that you think of, the things that you see in this new proposed federal privacy law: criminal justice, health, education, access to essential services like food and water, the kind of the usual things that you would be thinking about. And if you are using artificial intelligence or other automated decision-making in those contexts, I do think that the current laws will also capture you. And so particularly in the state of Colorado, you have to give, again, notice what does that mean? Transparency. They have some specific requirements about explaining the logic, about explaining why you need to use profiling to make this decision. There are 3 categories of opt-out. So if you are have a solely automated process, you must offer opt-out. If there's a human reviewed process, but the human doesn't change the decision, you must offer an opt-out. And then opt-out is discretionary if there's a human involved decision-making, meaning that a human could change the outcome. And then a data impact assessment is required before data collection starts. And if you collected data beforehand, then you may not use that data. So like you see disgorgement built into the law. So I think there's some things that companies have to think about. But I think foundationally, it has to get back down to, can you get meaningful consent? Because you really want to start with a clean data set. And we've tried to regulate in the middle, and we've got all this data out there and it's been used in all sorts of ways. But ideally, if you're starting from scratch, you're starting from a situation where people understand exactly what you plan to do with the data when you collect it.
Yeah, that's just helpful in a nutshell. And so much of this resonates with the work we're doing on the IEEE USA AI Policy Committee, right? It's a standards organization. And these are these questions, both in terms of auditing and risk assessment for these AI systems. Knowing we only have like a minute or two so we can get a couple questions in, I want to just go back to that executive order for a second, because there's so much of that focus on the countries of concern, but we're also talking about, it has a lot talking about, hey, DOJ, come up with regulations for consumer data. Oh, and here's 180 days to do it. What do you think, Kristi, in terms of, with your expertise and your long service in intelligence, is this national security focus from the administration, or is this really trying to bring consumer protection and protection for privacy for everyone?
I think it's a bit of both, but I think the executive order is one way to try to equalize the national security space, right? Because these countries, the countries that Lynn mentioned, China, Russia, Iran, North Korea, Cuba, Venezuela, they are able to procure very sensitive types of information, and the executive order covers biometric data, geolocation, financial information, and other information that is very significant. And so part of the challenge from a national security perspective is that if we have all of these regulations and executive orders on how US companies can procure sensitive information, what does that mean when other countries that are not democratic regimes can purchase that same data set and do it for all sorts of nefarious purposes? I think that it's going to be difficult to actually implement, and this is just my personal opinion, because those countries might be able to, they're not gonna say, hey, I'm North Korea, I'm here to purchase, you know, this biometric data set, and they're gonna use other methodologies to procure that same very data set. And so it's gonna be difficult to enforce, but I do think it's a clear signal from this administration to say, for certain types of information, we are not going to permit the offshoring of that information to certain regimes. But as you said, the devil's going to be in the details, and the Justice Department is going to have a group of experts looking at it, ways to actually implement this from a rulemaking perspective.
Thank you. And then Brian, how can I even say this in a minute? What does the future look like from the FTC's perspective for consumers? Because you're leading the fight.
Yeah, I'll keep it really short. So the outlook is grim for, no, I'm just kidding. I think it really depends on, I mean, so we're really at an inflection point in the internet, and it's similar to what we were back in the early 2010s and the early 2000s with Internet 2.0 and then mobile data. And to be frank, we're still dealing with the problems that those things caused. And so if we take a lesson from the past and we really start with privacy, instead of rushing out whatever products we can get out and then worrying about the privacy implications later, then I think it's going to look a wonderful opportunity to have wonderful technology that's privacy protective.
Do you hear that, Miranda? AI governance. All right, I'm going to turn over to our amazing law students, Deandra and Kyle, and we'll take a question for the panelists from the virtual, and then we'll go to the audience.
Thank you all for coming to speak with us today. We do have one question. How does data privacy intersect with the concerns around generative AI and elections, considering that we have an election coming up?
I mean, I'll answer that by saying, I think that right now people are trying to throw the book at AI. There are so many harms that can come out of generative AI, and it was released so quickly, before those harms have been addressed. People are trying to figure out what are the levers that can be pulled. And obviously data is so core to generative AI's function. Privacy is one way into that. But as you said, this is a huge election year. I think half the world's population is going to vote this year, including in the US. And it is unlikely that, emerging privacy legislation or existing ones are going to be the thing that will affect those harms this year. Models have already been built. Some of them are being challenged, not so much under privacy concerns, although in some cases, yes, more so in intellectual property and other sorts of harms. But they're already out there. They're being sold. They're being used. They're leading to the harms that we're concerned about already. And maybe over time, privacy laws will have a role to play in constraining the voracious appetite of AI developers and the data they collect. And ultimately that will lead to some constraints. But as AI gets better, also, you need less and less data as well. So it might be that privacy is not necessarily the best intervention, or privacy in a narrow sense, and thinking more about what are the impacts of the use of data and how do you address that. So fairness and bias, related expectations are one thing that are already coming up. Constraints around what other sort of outputs are needed, et cetera. So it has a role to play, but it's unlikely to be the determinative intervention for elections this year.
Okay. Any questions from the audience? We've got a mic if you've got questions. There's a lot, that we touched on. Anybody? Because we have more virtual questions if we've got we're almost out of time actually. So it's 12:59. No questions, going once, going twice. I like to run a tight ship. So I'm going to shut this down with a moment first to say thank you. These speakers in front of you and attending virtually are truly some of the leaders in this field. I would, respectfully disagree with Miranda that law doesn't have a role to play in this. I think it's critical, but
They didn't have a role to play. Just the speed of it is challenged.
True. But really, to have folks as distinguished as this is an honor here on our campus. And we're truly grateful for you traveling all the way down from DC. And Miranda, we're going to get you here next time. All right. Thank you very much. And thank you to the audience. Thank you, everyone. Have a really good rest of your afternoon.